Hello friends, I am Nupur and today I'll be telling you about the company's Fresh Start Scheme 2020. This scheme came by the Master Circular 11/2020, which was dated 24th March 2020 for the benefit of all the companies. This scheme shall come into force on 1st of April 2020 and shall remain into force till 30th September 2020. So let's discuss about what is the purpose of this scheme, what are its benefits, to whom it's applicable, what is the time period of this scheme, etc., and how companies can benefit from this scheme and how it is a fresh start for them. So this company's fresh start scheme is basically for all the companies which are already registered and not for those companies which are going to register in 2020. So let's get started. So let's first of all talk about what is the purpose of this scheme. The purpose of this scheme is to facilitate all the companies which are registered in India to make a fresh start on a clean state. It is actually a one-time opportunity to enable the companies to complete their pending compliances without any additional fees. So if you all know that whenever we register a company and we have to file all the annual compliances, we have to pay a certain amount of fees. That fees is a normal fees, which is on the basis of the authorized capital of the company. So if a person or if a company does not file their annual returns on time, and even when they delay it, they have to pay a lot of amount of additional fees. So by this scheme, the purpose is to give opportunity to all the companies to enable them to complete all their pending compliances, means the compliances that they have not completed on time, and they do not have to pay any additional fees for that. They just have to pay the normal fees and they can comply with all the compliances. This scheme also given one-time opportunity for all the defaulting companies to file all their belated documents. Defaulting companies are those companies which have not filed their compliances, which have defaulted in filing any of the compliances which are required to be filed by the companies. This scheme also provides an opportunity to inactive companies to get the companies declared as dormant company by filing simple application at normal fees. So there are companies which are inactive companies. They are not doing any business. So they can get the status of the dormant company. Dormant company means a sleeping company, and whenever they resume their business, again they can take the status of the active company. So for taking the status of the dormant company, they just have to file a simple form at the normal fees and they can get the status of the dormant company, and they also need not file any other compliances. Next, we talk about what are the benefits of the scheme. So the most and very important benefit is that they do not have to pay any additional fees on account of delay. Another benefit is that they are going to grant this scheme is going to grant the immunity from the prosecution or proceedings which otherwise would have occurred due to non-filing of certain documents. For example, you have not filed your annual returns on time. Then you may get a notice from the department regarding the annual filings, and you may be subject to any prosecution or any proceedings. But through this scheme, when you file all your documents, when you file all your pending compliances, you will be granted an immunity from prosecution or any proceedings which otherwise would have occurred because you have not filed these certain documents. After converting to dormant company remain and register with minimum compliances. As I have said, that if you are not doing any business and you're not running the business right now and you are about to resume it on a later date, then you can always do that, but your company will always remain on the registrar of companies with very minimum compliances. Next comes what is the applicability of the scheme, means to whom this scheme is applicable. Companies Fresh Start scheme, for whom this company Fresh Start scheme is applicable. Any defaulting company can file the belated documents which were due for filing on any given date in accordance with the provisions of the scheme. So this tells that you can file the belated documents for which were due for filing on any given date. On any given date means even if a company has not filed its return for past 5 years, it can do so under this scheme. So all the companies, defaulting companies, will include a foreign company also, that is including the foreign company which have a project office in India and the subsidiary of the foreign company. These companies might have been registered in India, and if they have not filed their compliances, they are defaulting company and they can do so and take the benefit of this scheme. Companies who have been automatically struck off due to non-filing of annual documents. For example, many of the companies have been automatically struck off from the registrar of the company because they have not filed their annual returns, they have not filed their annual documents. So those companies can take the benefit of this scheme. The struck off of the company has to approach the NCLT for reviving their companies first, and a copy order of NCLT approving for such revival under Section 252 of CA 2013 to be filled in form number INC 28. Later on, they can take the benefit of the scheme. Since the companies have already been struck off, they have to approach the National Company Law Tribunal, that is NCLT, for reviving their names, and then order copy of which has been received from the National Company Law Tribunal. They can attach that, and later on they can take the benefit of the scheme and find all the related documents. And it is also applicable to all the companies who want to go for strike-off voluntarily. If a person wants to go for strike-off, a company wants to go for strike-off, they can file all their documents and they can file STK2 and pay the government fees and go for strike-off of the company simply. Next is, to whom is this scheme not applicable? So this scheme is basically not applicable to companies against which final notice of a strike-off has already been initiated by the designated authority. If the designated authority has already issued the final notice of a strike-off or has initiated the final notice for strike-off of the company, then those companies cannot take the benefit of this scheme. It is also not for those companies which have filed an application for striking of the name of the company in the register of the company. So all those companies have already gone for the striking off of the companies voluntarily. Also for those companies, this scheme is not applicable. This scheme is also not applicable to the companies which are amalgamated under a scheme of compromise and arrangements. Those companies which have gone into amalgamation, this scheme is also not applicable to those companies. This is also not applicable to the companies which have filed application to obtain a dormant status. For example, any inactive company, it has gone to obtain a dormant status. This scheme is also not applicable to those companies. This scheme is not applicable to vanishing companies. Now, what are vanishing companies? Vanishing companies are basically those companies which raise the funds from the public through initial public offers, and subsequently they fail inter alia to comply with listing / filing of the requirements of the ROC and the stock exchanges for a period of 2 years, and were not found at their registered office address at the time of inspection done by the authorities of the stock exchange, and the directors are also not traceable. Means the companies, they have vanished, they have missed somewhere, they have gone somewhere, their registered office is not traceable, their directors are not traceable. For a complete period of 2 years, they have taken money through the initial public offers, and then they have not complied with the listing requirements of the registrar of the company. So those companies are the vanishing companies, and also for those companies, this scheme is not applicable. This scheme is also not applicable where the companies are marked as under CIRP, that is Corporate Insolvency Resolution Process or liquidation. The companies which are going for liquidation, which are insolvent, but this scheme is also not applicable for those companies. Now, what is the procedure for availing this one-time opportunity under the scheme? First of all, you simply have to file all your documents, related documents which you have not filed, by paying a normal fees. Normal fees is the amount just prescribed in the company's registration office and fees rules 2014 on the date of filing of each related document shall be payable. Then after you have filed all your documents, you will be filing an application for the issue of the immunity, because as we have told, the benefit of this scheme is that you will be getting the immunity from all the prosecutions and the proceedings which otherwise would have come if you have not filed your related documents. So now you have to file an application that so that the department can issue you the certificate of immunity. An application for seeking the immunity regarding related documents filed under the scheme shall be made in e-form CFSS, that is Companies Fresh Start Scheme 2020. After closure of the scheme and documents are taken on file and on record or approved by the designated authority, but before 6 months from the closure of the scheme. This scheme closes on 30th September 2020. So after September, 6 months from 30th September 2020, you have to file this form for the issue of the immunity. And there is no fees payable for filing this form. This form is completely free. You just have to file an application so that you can get the immunity certificate. So first of all, pay your normal fees, file all your documents. Secondly, you apply for the certificate of immunity. And thirdly, designated authority will issue the immunity certificate in respect of documents filed in the scheme based on the declaration made in Form CFSS 2020. So on the basis of the declaration that you have made in Form CFSS 2020, designated authority shall issue you the immunity certificate. So the procedure is very simple. You just have to file the belated documents by paying the normal fees, and you just have to apply for an immunity certificate, and then the designated authority, after verifying all the documents, after verifying the form that you have filed, it will issue the immunity certificate. And remember, there is no fees payable for filing the form under CFSS, and the time limit is 6 months from the end of the closure of this scheme. A scheme for inactive companies. Inactive companies, as I've said, that they can take the status of the dormant companies, and they can either make an application for obtaining dormant status in Form MSC1, which is at very normal fees, or they can go for the striking off by filing Form STK2 at normal fees. Now, cases where the company has filed an appeal. Now, if any defaulting company with respect to any statutory filing under the Act, or its officer in default has filed an appeal against any notice has been issued or complaint filed or order passed by any court or adjudicating authority, if the defaulting company has filed an appeal before a competent court or authority for violation of the provisions under Companies Act 1956 or Companies Act 2013, in respect of which application is made under this scheme, the applicant, before filing application in the scheme for issue of immunity certificate, withdraw appeal and furnish proof of such withdrawal along with the application. So in case a person has filed an appeal against which a notice has been issued, for example, a notice has been issued for filing all your belated document, and the person has filed an appeal against that, and now you want to avail this benefit of this scheme. So before filing an application in this scheme, he has to withdraw that appeal, and then he can file all the documents and he can apply for the immunity certificate. And while he is filing the immunity certificate application, he has to give a proof that he has withdrawn the appeal. Next is, in case order is passed but appeal could not be filed. For example, there are cases where the order has already been passed but you could not file the appeal. In this case, time period has been extended for the companies for which the order is already passed and the appeal could not be filed. So where an order regarding delay associated with filing of the document, statement or return, and penalties were imposed by an adjudication, or because all the penalties have already been imposed, so now nothing can be done. The person cannot avail the benefit of this scheme, and only the benefit is that he has been given a additional period of 120 days. So an appeal is not filed under 1st April 2020, and last date of appeal falls between 1st March 2020 and 31st May, that is March, April, May. If the date of the appeal is falling between any of these 3 months, then additional period of 120 days is given, that is until 28th September 2020, for filing an appeal before the concerned registered regional director. So in case any order is passed, appeal could not be filed. So the person cannot take the benefit of this scheme. Only benefit is that if the date of appeal is falling between 1st March 2020 and 31st May 2020, then additional period of 120 days is granted, and you can file the appeal up to 28 September 2020. Also, no prosecution regarding non-compliance of order or adjudicating authority has been initiated against the company during this additional period. So during this additional period, no prosecution order will also be initiated by the designator or adjudicating authority. Immunity not allowed in certain cases. Now, immunity from first cases, immunity from launch of prosecution or proceeding for imposing penalty shall be provided only to the extent such immunity from launch of prosecution or proceeding for imposing penalty under the Act pertains to any delay associated with filing of belated document. Any other consecution proceedings are not covered here. For example, under section 42 subsection 8, every company is required to file a return of allotment within the period provided therein. However, proviso to section 44 subsection 4 also requires utilization of money raised to private placement shall not be made unless the return of allotment has been filed by the company. Now, immunity under this scheme is available only in respect of proceedings for imposing penalty on account of delay in final return of allotment, but not on account of utilization of money raised for private placement prior to filing of return with registry. So, in case a person he has to file a return of allotment, and also there is a time period for utilization of the money which is raised with the private placement. So in this case, in this scheme, now this scheme shall be applicable only in case of delay, which is there in filing the return of allotment, and not in case when the time period is for the utilization of the money. So person may have delayed in filing the return, but he might have utilized the money according to the time limits which have been given of the money which is raised through the private placement. So immunity shall not be allowed in the case of the time period which is allowed for utilization of money which is raised through the private placement. So any immunity from the launch of prosecution proceeding shall be provided only to the extent is relating to the delay associated with filing of any belated documents. Any other consecution proceeding, any other proceeding, that is, for example, over here, that utilization of money which is raised through private placement, in this case, the immunity is not applicable. Okay. So case 2, an appeal is pending before the court of law in case of management disputes pending before the court of law or tribunal. If there is management dispute pending and the appeal is pending, then again the immunity is not allowed. The immunity is also not allowed, and in case an order of conviction has been passed by the court, non-order imposing penalty has been passed by adjudicating authority, as no appeal has been filed before the scheme came into force. Before this scheme came into force, no appeal has been filed because the immunity, the time period have been given from 1st March to 31st May. So if before that you should have filed an appeal and you have not filed the appeal, then immunity cannot be granted in that case, and no additional time period will also be given. There is a 2 dates are there. There is 31st August 2020 and 30th September 2020. So the belated documents can be filed without any additional fees till 31st August 2020. However, belated documents could be filed till 30th September and no prosecution or punishment proceedings would be launched. So conclusion of the scheme, at the conclusion of the scheme, designated authority shall take necessary action under the Act against the companies who have not availed the benefit of the scheme and are in default in filing these documents in a timely manner. So it is always better to take the benefit of the scheme, because this scheme has been introduced lately, and it is a huge benefit for the companies who have not filed their returns. So it's better to avail the scheme and take the benefit. If you want to go for strike off, you can go for strike off. If your company is inactive, you can take the status of dormant company, and your name shall be reserved. Your name shall be there in the register of the companies. So you can take the benefit of this scheme. So thank you, friends. Hope you have understood the company's fresher starter scheme. If there are any queries, post them in the comment section below. Thank you.